Hello, hello. Kamusta? Sino ba mga nandito? Welcome to the live streaming of the third session on the third day of the confirmation of charges hearing of the former President, Rodrigo Roa Duterte. The defense is going to present their submissions, their counter-arguments to the allegations put forth by the prosecutors and the victims. Kumusta kayo dyan? So, hinihintay na lang natin na mag-live na sila at i-refresh ko muna to. Baka nag-live na nga. Wala pa. Okay, wala pa, no? Oy, thank you nga pala. Si Shabigale 1123, no, for joining sa membership natin. Hindi na natin na ano yung ating membership, no, doon. Pero salamat at salamat sa mga previous live namin doon sa Third Floor Studio, sa nagpapakulay, nagpapadala ng inyong mga suporta. We appreciate that really so much. Thank you. And if you can do so, subscribe to YouTube, my YouTube channel, as well as our Great Conversations na channel with Pam Pedroche, and as well as the Third Floor Studios na YouTube. And then you can also follow me on two of my Facebook accounts, on Twitter as well, and on TikTok. Although wala tayo sa TikTok at sa Twitter masyado. Nasa Facebook lang tayo, dalawang accounts at YouTube. But hopefully, mabigyan natin ng content. We're a one-man show dito, and medyo marami din tayong ginagawa with our advocacy at Maisog and the Save the Philippines Coalition. So medyo talagang gipit tayo sa oras, no? Ayan na. Mayong gabi kaninyong tanan, mga Bisaya. Magandang gabi sa lahat ng ating mga kababayan, nasaan man kayo sa mundo at sa mga isla ng Pilipinas. Welcome to the Amateur Pundit Live special coverage of the confirmation of charges hearing ni Pangulong Duterte. Ano ba yung take natin kanina? Well, kanina, napakaganda ng counter-arguments ni Attorney Nicholas Kaufman. Ginisa sa sariling mantika yung prosecutors at hindi nga naipakita ni Attorney Kaufman na hindi talaga na-establish yung tinatawag na causal link to establish na itong si former President Duterte ay siya ngang may polisiya at may direktiba na nagpatupad nung tinatawag nilang state policy or state-sanctioned extrajudicial killings, which led to the charges of crimes against humanity. Yun ang nakita natin kanina. At una na dyan ay yung definition nga, ano ba yung crimes against humanity, ano ba yung mga requirements, ano ba yung elements present that should constitute crimes against humanity, ano ba yung mga ini-establish na grounds, una na, isa na doon ang indirect perpetration, yung siya daw yung may sala indirectly, at doon na nga pumasok yung tinatawag na causal link. Ano ba yung causal link, Yung causation kasi is different from correlation, at na-establish nga yan doon sa last point ni Attorney Kaufman na kung titingnan ninyo yung percentage at yung data during PRRD's drug war, ikumpara mo sa data sa crimes or sa mga death perpetrated or committed by law enforcement in the first year of the Marcos administration, mas marami pa, mas mataas pa ang percentage ng mga nangamatay in police operations sa panahon ni Bongbong Marcos. Okay? Sinabi din at na-mention din, Jen, maraming salamat. Windy City, Chicago. Jen, maraming salamat. Ito si Jen, no? Nandun sa Great Conversations, nandun sa third floor, nandito sa YouTube ko. Salamat talaga, Jen, no? For your undying support. Hopefully we can meet one of these days, no? Pag nabisita ka ulit dito sa Pilipinas. Salamat, Jen, no? So yun na nga, no, na-establish nga ni, medyo mahirap yun i-debunk. In fact, even Karen Davila, no, stressed it kanina doon sa TV Patrol. So ano ba yung causal link, no? Yung causal link, to put it simply, ito yung parang tulay, no? Para bang tulay na nag-uugnay sa isang precedence, no? At sa isang dahilan para masabi natin na yung epekto, no, ay dulot nga sa isang dahilan. Okay? Ang dahilan daw, as alleged, ay yung pulisiyan ni Pangulong Duterte na ang epekto ay patayin at mag-conduct ng extrajudicial killings tantamount to crimes against humanity. So, ano ba yung causal link? Ano ba yung tulay na dapat ma-establish, no, ng prosecutor? Ang tulay na yon, no, hindi yon rhetoric, no? Hindi yon yung speeches ni former President Duterte na strongman statements, because statements cannot prove a crime. You have to establish na merong krimen base doon sa kanyang mga pronouncements or speeches. Pangalawa, na-debunk na yon kasi based on those statements, may mga hindi nabanggit ang prosecution side na nagpapalabas na hindi pala totoo yung konteksto na yon, at it was taken out of context because some parts, no, and most significant parts of those speeches were not quoted, no, were not even in fact admitted as evidence by the prosecution. At pangalawa, yung smoking gun na sinasabi nila, yung memorandum circular ba yun, patungkol nga doon sa Oakland double barrel, no, na kung tawagin nila ay siyang smoking gun, na ipakita din ni Attorney Kaufman doon na sa dokumentong iyon, nandun sa baba ang sinabi na in conducting these operations, you have to respect the rights accorded to each suspect according to our Constitution and international law. Nandun yun. Mag-umpisa na ata. Okay? Mag-umpisa na. Ayan na si Mutok. Ayan na si
Yes, veuillez vous lever.
Ayan na yung mga putangina. Pasok! Pasok! Ito na yung beer ko na malamig. Classic Heineken.
Please be seated. Veuillez vous asseoir.
Bonjour à tous.
Judge Motok, good afternoon. I'd like to begin with an oral ruling regarding the redactions made to the transcript and direct broadcasting today. The Chamber notes that redactions were made to the transcript and to the direct broadcast of the hearing subsequent to an application by the prosecution and which was opposed by the defense. The application of the requested redactions apparently would be a problem and could lead to hearings being held in closed session. The Chamber wishes to recall an earlier ruling during which the Chamber stressed that it is up to the parties and participants to ensure that their submissions are worded in such a way as to avoid going into closed sessions, thus ensuring the transparency of the proceedings and to avoid the disclosure of confidential information. The Chamber would remind the parties to comply with these instructions. Furthermore, the Chamber is of the view that the information that was asked to be redacted and also from the direct broadcast today were limited to identifying information of witnesses and victims mentioned during the submissions. The defense disclosed information on several occasions that allowed for the identification of victims and witnesses. For example, positions held and nicknames, things that must not be disclosed so as to ensure the protection of witnesses and victims. The redactions had only to do with identifying information and were not as general, were not general redactions to the events within the case. This was the appropriate recourse to implement the Chamber's duty to protect the safety and well-being, including psychological well-being, the dignity and privacy of victims and witnesses in accordance with Article 68 of the Rome Statute, without having to hold the hearing in private or closed session. Thus, the Chamber has decided to maintain the redactions that were applied earlier and reminds the defense not to disclose information that may not be necessary and information that could identify witnesses and victims in accordance with Article 8 of the Code of Conduct of Counsel. I thank you very much. And Mr. Kaufman, you may now proceed and continue your submissions on the merits. You have until 3 p.m. Thank you very much.
President, as you can see, we have a number of yellow post-its on our table here. These are the document identification numbers of all the matters that I'll be talking about. But since we only have until 3 and until 1 hour tomorrow morning, I can provide the ID number if necessary, but I will move on, and we promise to give the Chamber at the conclusion of the hearing the full ID numbers of everything that I've talked about. And if the prosecution obviously wants something as well, he can.
Afternoon, Madam President. I would just ask my friend if he can read out the tab numbers, because every item per the Chamber's instruction has a tab number. So even if my friend doesn't read out the entire ERN of the page he's citing, the lines, if he gives us a tab number, at least we can check his homework in real time.
Merci beaucoup.
Thank you very much. Counsel, are you in agreement with this position taken by the prosecution? Well, the representative of the OTP. Mr. Kaufman, yes, ma'am. Judge Motik, please proceed.
Come to ask myself another question concerning the nature of a common plan theory, which applies equally to its subjective requirements. Has the prosecution shown substantial grounds to believe that Rodrigo Duterte's implementation of its fantasy criminal scheme was of such a nature that the murders detailed in its 49 charged incidents would have ensued as a virtual certainty in the ordinary course of events, and that he foresaw that they would occur as a virtual certainty in the normal course of events? Let us take a moment so that I can assure you that these wonderful words, virtual certainty, actually do exist in the court's case precedent and are not a fiction of my own. If you will, please display the first of 2 citations from the Abdul Rahman, otherwise known as the Ali Kushaib trial judgment from 2025. First of all, paragraph 795. While the common plan between individuals need not be specifically directed at the commission of a crime, it must nevertheless involve a critical element of criminality, meaning that in the context of the specificities of the case, it was virtually certain that the implementation of the common plan would lead to the commission of crimes. We can have a look at paragraph 706, and it talks about the general knowledge requirements, which I am sure your honours are very familiar with. So, with respect to the question whether the common plan entailed the occurrence of murders as a virtual certainty, the answer is an emphatic and resounding no. First of all, let us recall what the prosecution defines as the former president's list of high-value targets, what the media calls the kill list, and what one of Mr. Edward Jeremy's quoted witnesses referred to as the dead list. The number of individuals on this so-called kill list, the very list on which the prosecution relies to show that the knowledge that death would ensue, is 4,817. Those who are actually neutralized dwarfs in comparison and stands at 248. So, assuming that neutralized actually means killed, which it does not, then there is no virtual certainty attributable to Rodrigo Duterte that death would ensue from this kill list. Rather, a 5% chance. Let us have a look at a bar chart for exactly the same figures used by the prosecution as distributed geographically. I now turn to the issue of control, as it did or did not manifest itself in the crime base. In other words, can it safely be argued that substantial grounds exist to believe that Mr. Duterte's supposed diktat filtered its way down from his mouth and via his co-perpetrators to those who were supposedly going about committing these murders? How has the prosecution shown the concept of automatic compliance, or even virtually automatic compliance, so essential to its pyramidal structure? Well, by and large, and judging from Ms. Robin Croft's submissions, it would appear that the concept of automatic compliance is substantiated by reference to subjective comments made by perpetrators who talk about their will being controlled. For example, transcript, page 37, line 7 onwards. I felt like that I didn't have any choice but to follow their orders. It wasn't possible not to obey his commands. Another example, transcript, page 38, line 17. Co-perpetrators controlled the will of the physical perpetrators. End quote. According to the prosecution, members of the Davao Death Squad had to seek clearance from Mr. Duterte to conduct killings in Davao City. For this wild assertion, the prosecution relies once again on the evidence of criminals it has recruited, all of whom are inherently unreliable because of their being self-confessed vicious murderers, testifying in return for virtual immunity from proceedings at the ICC. We shall analyze the testimonies emanating from these individuals in detail later in my submissions. Now, I can see Mr. Nichols scribbling away there, but I shall be referring to what are called statements of limited use. As for the other modes of liability charged, ordering under Article 25(3)(b and Article 25(3)(c), aiding and abetting, as I have said, no smoking gun, no evidence of a direct order, solicitation, or inducement with respect to any one of the 49 incidents. No documentary record exists of a presidential order. So how could these orders have been transmitted for the purposes of Article 25(3)(b)? Well, unless Mr. Nichols envisages mental telepathy, I think that we can discount ordering. The prosecution has failed to elaborate in its oral submissions what it means truly by soliciting. If it means the ambiguous public speeches, then it is difficult to reconcile the frequent exhortations to self-defense with soliciting, unless, of course, you accept that Mr. Duterte super craftily inserted these exonerating comments into his speeches in order to craft himself a defense when the day of reckoning would come. As the prosecution asserts, speaking with a forked tongue, sometimes speaking his mind, sometimes saying what he wants you, your honours, to hear. Furthermore, generalized statements months before specific incidents do not establish causation or instruction. For aiding and abetting, there is no reliable evidence that Mr. Duterte provided practical assistance, encouragement, or moral support that substantially affected the commission of a crime with knowledge of the perpetrator's intent. And finally, on modes of perpetration, modes of liability, I would beg you not to take heed of Ms. Paulina Masseter's assertion that Rodrigo Duterte failed to prevent or punish. The prosecution has not charged command responsibility under Article 28. And the reasons for that are clear. It is the same reason why it cannot prove ordering. There is no ascertainable chain of command descending from Duterte at the top via the co-perpetrators, so-called co-perpetrators, all the way down to the crime base. As I said, it all breaks down at the level of the co-perpetrators. And I would ask you very respectfully not to exercise your discretion to requalify pursuant to Regulation 55, the regulations of the court. But if you do, and you shouldn't, I respectfully submit, you should order the prosecution to resubmit its document containing the charges and its pre-confirmation brief as amended, and to release Mr. Duterte in the interim. Now, I have finished that section of my submission, and I will now turn to the witnesses themselves, and I will be very careful not to mention anything that I'm not meant to. And I will discuss, first of all, the general reliability. A genuine criminal investigation is meant to be directed at establishing the truth. It is meant to elicit facts in an impartial manner and not to present witnesses with a preconceived idea and to seek confirmation thereof, whether it be by way of leading questions or anything else. By this, I mean that the golden thread linking practically every one of the interviews of the prosecution's so-called insider witnesses, who are, for the most part, ruthless criminals, is the a priori targeting of Rodrigo Duterte. In my submission, no real attempt was made to perform this duty of examining exonerating circumstances, or even to establish the existence of other actors who might be responsible for the high incidence of deaths in the context of the war on drugs. Most prosecutors will collate the evidence and thereafter analyze it and decide whether to prosecute with a view to obtaining a reasonable prospect of conviction, which is indeed the standard supposedly applied since Mr. Karim Khan assumed the role of chief prosecutor. A prosecutor is not meant to choose his target in advance and then find the evidence to support a preconceived desire. Now, I'm not going to engage upon a wholesale forensic analysis of the credibility of each and every witness. I am long enough in the tooth to appreciate that issues of credibility and weight are not normally litigated at confirmation, but are left to trial. This case, however, is unique. And as I have said, the prosecution's star witnesses are self-confessed murderers. And most of their statements were taken by the prosecution's investigators with the assurance of limited use. Namely, that anything self-incriminating would not be used against them in proceedings at the ICC. Although Mr. Nichols will undoubtedly tell you that these agreements of limited use are not to be understood as the grant of immunity from prosecution, for all intents and purposes, they are. And I am prepared to wager that we will not see even one, not one, of these incriminating witnesses in a dock at this court, nor in a dock at any court anywhere in the world, after they have been rehoused and given protection at considerable expense to the state parties funding this court. I do not think that I would be alone either in believing that there is something morally repugnant or even questionable from a public policy standpoint to shield not only one, but a number of murderers from prosecution at the ICC just in an attempt to nail Rodrigo Duterte. Indeed, in many common law jurisdictions, the use of a self-avowed murderer to convict an alleged murderer would normally entail vetting and scrutiny of the highest order. Those words, if I'm not mistaken, come from the Crown Prosecution Service's instruction manual. Public source. In fact, I would suggest that it would normally only be approved, firstly, when it is considered of more value to have a suspected person as a witness than as a possible accused. Secondly, whether obtaining the conviction of an alleged murderer is more important than the release of a self-confessed murderer. And finally, whether it is likely that a conviction could be obtained without the cooperation of the self-confessed murderer, or a number of them. Even after this vetting process, most courts and common law jurisdictions require an evidentiary supplement before relying on the sole testimony of a cooperating criminal witness, or what is otherwise called an accomplice witness. Such an evidentiary supplement in legal parlance is called corroboration, and rules exist governing what may be deemed suitable corroboration. I'm pretty sure that these considerations were never considered by the prosecution for one very simple reason. At least two of the most prominent accomplice witnesses were offered up to the prosecution on a silver platter, and I cannot say by who in open session. Neither the Rome Statute nor its accompanying texts regulate the way statements of limited use are employed. I would like the pretrial chamber to consider the way academics and the prosecution itself has qualified the implementation of limited use statements in the past. And I quote from paragraph 49, which is open source, of a chapter on the Office of the Prosecutor in the 2022 edition of the Max Planck Encyclopedia of International Law, written by no less than Judge Betty Hohler of this court. And I quote, "One of the agreements the OTP may enter into during the investigation is an agreement with a person suspected of committing crimes within the jurisdiction of the court, is to provide a statement of limited use. The idea is that the person provides the Office of the Prosecutor with an oral or written statement for the purpose of pursuing leads or developing additional information or evidence on the condition that the statement will not be used against the interviewed person except as stipulated in the agreement. The purpose of such agreements is to ensure cooperation of so-called insider witnesses whom the OTP does not intend to prosecute, but are expected to provide key information or evidence against other, usually more senior suspects." Judge Hohler was effectively relying on footnote 20 to the prosecution's own filing, number 1118, in the Bemba Article 70 case, which states the same thing. Both sources stress that limited use statements should be used as a rule to pursue leads or to develop information, but not apparently, outright at any rate, to serve as the key and main testimony against a suspect. In my opinion, there is a good reason for this, and it is contained in the wording of Article 54, 3D of the Rome Statute, which is cited as the statutory basis for limited use statements. The prosecutor is entitled to enter into such agreements granting limited use on condition that the agreement would not be inconsistent with the statute. And I stress those words, not inconsistent with the statute. Using the evidence of self-confessed murderers to obtain leads or develop evidence from other sources, I would suggest, is consistent with the statute, as mentioned by Judge Betty Hohler. To give a get-out-of-jail card, however, to a whole bunch of murderers in order to fix liability to another, albeit pre-selected individual, also selected of murder, is, in my opinion, totally and wholly inconsistent with the object and purpose of the Rome Statute, which, according to its preamble, oft cited by the victims and the prosecution, is dedicated to the eradication of impunity. In my opinion, granting immunity to a murder suspect for core international crimes would be seen as undermining the object and purpose of the Rome Statute. Accordingly, I would ask the Chamber to find the statements of those witnesses afforded such limited use and to be of negligible evidentiary weight. Another issue pertaining to the general credibility of the prosecution's witnesses is the way in which they were recruited. In my opening remarks a couple of days ago, I talked about the general fairness of pursuing charges brought by a prosecutor who was formerly a representative for more than 100 victims of Mr. Duterte's alleged crimes. I also talked about a recorded telephone conversation in which one of the participants bragged about acting as President Marcos Jr.'s silent partner for channeling witnesses to the ICC. Apparently, I raised the presidential spokesperson's hackles considerably. So let me quote a bit more so that I can assure her that my cognitive faculties, which she doubted, are in fact intact. And this is what this covertly recorded individual, who I'm forbidden from naming, said. They cooperate through me, since I don't hold a position, redacted. But we are able to do it. So what? What happened here is an ICC investigator will give me a list of witnesses, documents they need to bolster the case against Duterte. Then I provide it. I give it to the different agencies so it can be approved. There are witnesses who need a pardon. I get the authority from the president, and they are granted a pardon. Basically, like that, it becomes a priority mission of the government. I don't think I've disclosed here, Madam President, any working methodology of the Office of the Prosecutor. So now I turn to the incidents themselves, the 49 incidents. The prosecution invites you to view these incidents as the manifestation of a much larger pattern. To quote the prosecution's very words in filing number 330 at paragraph 5, the 49 incidents are a non-exhaustive list of examples of the conduct underlying the charges. Indeed, the prosecution speaks of thousands of victims in toto, data sets, and patterns of violence. Now, the defense does not deny that much drug-related violence did occur. It was occurring before Mr. Duterte assumed the reins of power and continued, as we have shown, by way of a sharp increase after he left office. But these grandiose visions of the prosecution are of no avail if the core criminality and incidents alleged in its document containing the charges are not made out. So the question before you is whether there are substantial grounds to believe, firstly, that each of these specific incidents were unlawful killings, namely deliberate acts of murder, and secondly, that they were knowingly committed to further the criminal objective of the so-called common plan or the state organizational policy with which it has been conflated. And finally, that they are indeed attributable to Mr. Duterte under a recognized mode of liability. Preempting a possible defense, always a good tactic for a prosecutor, unsure of the strength of his own case, there is a heavy reliance on expert analysis of data sets to argue that reported instances of self-defense were statistically improbable. Let me stress that it is the defense's view that if the contextual case depends on the scale of victims, namely thousands, as alleged by the prosecution, then establishing the evidentiary integrity of each charged incident is imperative. In other words, the defense firmly submits that the pretrial chamber should not commit any one of the 49 incidents to trial unless it concludes that there are substantial grounds to believe that Mr. Duterte's criminal linkage and liability has been established for each one. When these 49 incidents are disaggregated and examined one by one, as the statute requires, we submit, what becomes apparent is not the cumulative strength, rather the recurrence of certain symptoms of inherent weakness in the evidence. These weaknesses fall into 6 broad categories. The first is the over-heavy reliance on the testimony of cooperating witnesses who are inherent criminals with an inherent propensity to be unreliable and whose statements, as I mentioned, are not corroborated by external evidence. The second, hearsay attribution, or in less legal parlance, incriminating statements heard from a source twice or even 3 times removed. The third weakness, which infects the evidence, is the fact that some of the victims are unidentified, making it virtually impossible for the defense to pursue its own lines of inquiry. This weakness affects at least 9 out of the 49 incidents. The fourth weakness, documentary records, such as police and forensic reports, are at variance with and are contradicted by testimony of a single prosecution witness. Fifth, the hoary old chestnut of conflicting statements emanating from 2 or more witnesses testifying to the same event, some contradicting one another, some contradicting even themselves. And finally, the 6th weakness being the repeated absence of any evidence to link the hitmen to our client, despite the prosecution's best efforts to chivvy such linkage out of them. The defense will now show how these identified weaknesses reduce below the substantial grounds threshold the evidence for these incidents in the 3 counts as they appear in the document containing the charges. Count 1, the alleged murders during the mayoral period. Count 2, alleged murders of HVTs, the high-value targets, during the presidential period. And count 3, barangay clearance operations also during the presidential period. So I shall start with count 1. As we know, the first cluster of incidents falling under count 1 concerns the so-called and totally fictitious Davao Death Squad period. This concerns incidents 1 through 9 of the document containing the charges. The prosecution's attribution theory here is straightforward, that Rodrigo Duterte, as mayor, authorized killings through intermediaries. But when the evidence for this count is examined, as I've already mentioned, not one witness can say that he heard the mayor give an order to kill. The attribution of criminality to Mr. Duterte arises, for the most part, out of assumption layered on top of hearsay and follows a repetitive pattern which would, as a rule, entail the same mechanism of attribution. Namely, a hitman witness for the prosecution would state that his handler said that clearance came from, and I quote, above. But what does the word above mean? It means an unnamed superior and nothing more. The mode of liability imputed to Mr. Duterte, namely indirect perpetration, requires the prosecution to establish a stable chain of command through which the common enterprise filtered. If there indeed existed a structured approval process, as the prosecution alleges, one would expect operational consistency, not variability. The incidents contained in count 1 are also marked by internal inconsistencies, which cannot be reconciled and which are indicative of the fragility of the prosecution's overall case. Incident number 1, for example, is based on the evidence of 2 witnesses who contradict each other on fundamental and materially crucial issues. Let me explain in more detail. P26, who presents himself as a participant, claims that Mr. Duterte telephoned a redacted third party to order the operation and was told that it was the mayor on the phone. Was told that the mayor was on the phone. Pure hearsay. The prosecution seeks to reinforce this through P2. Yet P2 was not present at the time. He was inactive for reasons I can't mention, and relies entirely on what he heard from the redacted third party and another individual at a later date. P2's account is therefore pure, unadulterated hearsay. More significantly, it diverges from P26's version on fundamental points. The year of the incident, 2014 and not 2013. The number of victims, 2 rather than 3. The identity of the perpetrators. The channel through which alleged clearance was conveyed, via driver and bodyguard, to a different DDS member rather than through redacted. And if that is not enough, the method of killing, strangulation rather than stabbing, these aren't minor inconsistencies. They concern the core factual matrix. If the pre-trial chamber is unable to determine even these basic circumstances which establish opportunity, method,
Redacted yan, redacted. Redacted, oh. Bakit na-redact yun? Wala namang dinisclose. Bakit ba na-redact? Ha? Ni-redact nila, baka masundan natin at maituro natin sino yung mga taong yun, no? No? Wala namang minensyon na pangalan, posisyon. Oh. Ba't ni-redact yun? Tangina. Nag-a-eye roll na si Mutok, no? Senyas-senyas daw. Wala, grabe nung, ha? Meron daw nagbibida dyan sa ICC. Yung na siya daw yung inano ni Bongbong Marcos at magbibigay ng lista. Ha? Walang iya talaga tong mga putang ina. Ang galing ni Kaufman, no? Talagang demolish, no? Talagang wow. Ang galing ni tama, nilampaso ni Attorney Kaufman, no? Naggaganyan na lang siya. Yeah, because tama, no? We have to remember this is a crime committed. And this is not just an ordinary crime of murder. A crime has to be proven beyond reasonable doubt. Nicholas Kaufman do not need to prove the innocence of former President Duterte. The burden of proof is in the prosecutors to prove beyond reasonable doubt that Mr. Duterte ordered the killings and instituted a state policy to implement those orders beyond reasonable doubt. Kahit meron ka lang 0.1% na doubt. Okay,
It's
balik.
conjecture. We
Conjecture.
would submit that Article 61(7) of the Rome Statute does not permit charges to be confirmed on the basis of conjecture, on the basis of such a weak evidentiary basis. Now, since the prosecution made such a big deal out of incident 3 on Monday and screened the video of the hit job itself, if you recall, the one in a marketplace, which was supposedly viewed with approval by our client, I would like to devote a few words to it. If your honors follow the transcript that accompanies this video viewing session, the prosecution fixated on the comments of Mr. Duterte telling the person operating the video not to zoom in.
Ayan na naman, niredact na naman ng mga putang ina. This Attorney Kaufman was about to present, no, his case on the video, no, na pinakita ng mga prosecutors na merong mga subtitles, and they were claiming that that an extrajudicial killing was being perpetrated real time by the alleged hitman of Rodrigo Duterte, while the mayor then, si Digong, no, was monitoring it on the CCTV. And today, February 26, the journalist who took that video executed an affidavit. Nung kanina nag-live tayo sa first session, diniscuss natin yan, kung saan sinabi niya, no? Kasi it was done in Bisaya yung pag-uusap nila PRRD. Ang sabi dun, they were viewing a recorded footage of the CCTV, no? Because pinakita ni then Mayor Duterte gaano ka-epektibo ang bago nilang CCTV system, no, doon sa Central 911 program project ng Davao City, no. Pinakita niya na noong panahon yon in 2013, no, ganun na sila ka-high-tech tulad sa Makati. That was 13 years ago, and that crime, no, was committed, no, 15 days before. Because that video footage showing Mr. Duterte looking at the footage, no, was made on December 19, but the actual crime happened on December 4, 2013 in Agdao, and that the police has already investigated that incident, and that the journalist, no, who owns that video filed a separate report for that killing, for that incident. Bakit nila niredact? It's public knowledge na, nakita na natin. Public knowledge na rin na yung may-ari ng video na yon ay dininay niya. At sinabi pa nga niya, he can present an evidence that the prosecutors misrepresented what was contained in that video, the conversation, no, and the context. Kasi it was just a splice of his original video. Pero ang tanong dyan, sabi ng journalist na si Ben Jason Tessiona, if I'm not mistaken, ang sabi niya, private video ngayon, nasa phone lang niya yun. Bakit nakuha ngayon nitong mga prosecutors? Paano nila kinuha yung kopya na yun without the explicit and expressed permission of the owner? Did they do some sort of hacking to his phone? Or whatever did they do? Kasi siya lang eh. Nasa phone niya and he never published that according to him in his affidavit. Ngayon, nirida. Paano ngayon yan? Gusto nila ng transparency, oh. Pero it does not risk revealing the identity of any witness. Diba? Kasi nga, ang identity nga nung may-ari ng video na nag-claim ngayon, meron ng affidavit eh. At I would surmise na nasa kay Attorney Martin Delgra na yung affidavit na yun. Questioning the ICC, asking the ICC to delete that video, and asking, no, the ICC and the prosecutors to issue a public apology. Otherwise, itong si Ben Jason will file appropriate charges against the prosecutors, specifically Julian Nichols. So, paano ngayon yan? Niredact nila, oh. Kasi hindi pabor sa kanila, oh. Walang hiya. Even the identities of the witnesses and the victims or the insider agents. Alam nyo, lahat ng identities ng mga co-perpetrators at ni PRRD, nilabas na nila eh. Eh bakit ngayon, ang itong witness na ito, na nasa protection na ngayon nila, eh ayaw pa nilang ipalabas. No? So again, makikita natin na ICC is not applying the same standard to the defense compared to the prosecutor side. So ngayon, anong mangyayari dyan? No? And I'm pretty sure gagamitin yan ni Attorney Kaufman at maliban pa yan sa affidavit ng 18 former Marines, no, or 14 former Marines and 2 Philippine Army and Army Reservists. Tama si Mandirigma. Sino ba yun? Oh, ito. Tama si Ian Russell. Ian Russell Aden. Nung pinakita nila yung video, walang reduction. Oh, ngayon, kinestyon ni Kaufman, nire-redact ngayon nila. Walang iya. Gago talaga. Ha? Ito yung sinasabi natin. In a fair and neutral and in a fair and impartial court, no, these charges will not hold water. And even during the arguments of Attorney Kaufman kanina, wala na, no? Talagang ibabasura na yung charges na yan. In a fair and impartial trial, or in a fair and impartial pre-trial proceedings, pero yun, na-prejudge na nila yung matanda. Gusto talaga nila na mag-proceed sa trial ito. Ewan ko paano nila gagawin ito. The whole world is watching. The entire Filipino nation is watching. This case will be enshrined in international legal history and jurisprudence, and will be a test case on the impartiality of the ICC. It will be a measure of how the ICC conducts its responsibility, how the ICC treats accused, and if the ICC is still relevant to the current geopolitical structure that is ever-changing sa ating mundo ngayon. Tulad niya, no? Nire-redact nila. They were surprised na merong nag-claim. They're not doing their homework. Sabi nga ni Attorney Kaufman kanina, no? Sa dami-dami ba naman ng database ng prosecutor, they did not do their job. Nag-type lang siguro sila ng mga keyword searches. Nakita nila yung portion ng mga speeches ni PRRD, ginamit na nila without even exerting effort to read through all those transcripts. No, wala bang contradicting statements doon sa mismong diskurso na yun, the same speech. At nakitaan niya ni Attorney Kaufman, pinakita nga niya kanina na meron. No, parang nag-Google search lang pala tong mga gago. Walang ya. Ngayon, no, nasa alanganin na sila. Tingnan mo. Kanina nga, nag-technical na yung inaano eh. No, sabi ni Presiding Judge Mutok, no, yung nag-warn siya sa defense na hindi daw i-mention yung para yung reduction part. Nag-manifest ang prosecutor na dapat daw sabihin ni Kaufman ano yung tab, no? Kasi nagme-mention sila ng transcript or document, meron yung tab eh. Kahit na daw wala na yung specific na identifier ng exhibit na yon, ang tab lang daw. Tinetechnical na nila eh. Kasi ang ganda ng mga argumento ni Kaufman, talagang nababasag sila. Di ba? So ngayon, anong gagawin nila dito? Remember, the question on the jurisdiction of the ICC over the case of former President Duterte is still being debated and unresolved up to this very moment doon sa appeals chamber ng ICC. Imagine, hindi pa nila na-resolve yung question of jurisdiction, but they are still proceeding with the pre-trial. Paano ka makaka-proceed ng isang pre-trial mo, no, na meron pang katanungan kung meron ka ba talagang totoong jurisdiction? Di ba? Ano ba yung rules nila dyan? No? Pwede mo mag-proceed ng pre-trial chamber na meron pang nakabinbin na apela doon sa appeals chamber on the question of jurisdiction? Di ba? At ngayon, no, imagine this, no, out of nowhere, came this guy who owns the video na ngayon nga ay pinag-uusapan dyan na nire-redact nila. Tapos meron pang affidavit ang 18 Marines kung saan Attorney Levito Baligod promised during the press con na magsasubmit sila ng kopya doon mismo sa ICC at sa mga embahada ng mga bansa na kasalukuyang kasanib or miyembro ng ICC.
Judge Motok, thank you, Mr. Kaufman. We've come to the end of today's hearing, the third day. The hearing shall resume tomorrow at 10 a.m. Thank you, parties and participants. I thank our interpreters, the registry, the technical staff, and all those who have allowed this. Yes, Mr. Nichols?
To interrupt, Your Honors, just at the end of the day, but I wonder if we could go into private session for 1 minute before you leave the bench.
Oui, Mr. Nichols.
Yes,
Oh.
Mr. Nichols?
Para ano to, the equivalent of an executive session. 1 minute daw. 1 minute na executive session. 1 minute na private session. Oh, yan na. Private or closed session. Tingnan nyo. Ano yan? Para bang yung tatawagin yung yung mga 'di ba sa nakikita nyo sa mga yung mga legal series ng mga legal yung mga movies, 'di ba? To my chambers, 'di ba? Tatawagin ng judge yung mga counsel to my chambers at magpa-private caucus sila doon, ito yung ginagawa nila ngayon. So, alam ko merong diyan. Meron diyang mga pag-uusap, meron diyang mga quid pro quo, meron diyang mga ang tawag diyan, mga concessions, meron diyang mga magtatawaran kumbaga. Kumbaga sa marketplace, magtatawaran 'yan. Pare, wag mo naman kaming ipahiyang masyado, paring Nick. Sasabihin ng ni Julian, tingnan mo si Julian, ang kanina si Nichols. Sasabihin, paring Nick, huwag nyo naman kaming boljakin ng todo, mahihiya kami, putang ina, paring Nick. Huwag naman masyadong galingan. Huwag mo naman masyadong galingan, paring Nick. Nalulusaw na kami dito. Tapos sasabihin ni Atty. Kaufman, okay, ano bang mai-offer nyo? Hindi ko gagalingan, hindi ko masyadong idiin yung kapalpakan ninyo. Ano ba yung pwede mong i-offer sa akin? Para hindi ko galingan. Mag-uusap yan. Sasabihin ng prosecutor, kukonsultahin niya si judge, Your Honor. Pwede ba na ganito na lang, Your Honor? Ganyan, Your Honor. We promise, Your Honor, na gagawin namin yung ganyan, Your Honor. Sasabihin ng judge, si Yulia Mutok. Sasabihin niya, paring Nick, okay ka sa sinabi ni paring Julian. Magkasundo kayo. Tapos sabihin ni Atty. Kaufman, titingnan niya, okay kaya to sa client ko? Parang okay ito. Sige, paring Julian. Handshake. Sasabihin ng judge, okay. Okay, ha? Yun. Sir, naglabasan ng mga legal counsel, Attorney Sal, nasa labas na, sir. Okay. May interview ba? Oo nga, naglabasan na sila kasi nga this is a 30-minute delayed na live stream, no? Natapos na to 30 minutes ago. Kaya naglabasan na sila. So, ngayon, i-monitor na lang natin, meron bang mga interview sina Attorney Salpanelo? Oo. Pero tingnan natin, naka-private or closed session pa sila eh. Abangan natin, baka lalabas pa yung mga huwis. Titingnan pa natin, baka may advisory, ano yung mangyayari bukas. Yaman lang din na nandito na tayo. Antayin na lang muna natin na matapos yung closed door session. No? Kasi lalabas pa yan eh. It has to be formally adjourned, no, yung hearing ngayon on record. Pero yun, no? Istorya sa tayo, inom sa tagamay, Cheers, Attorney Kaufman. Bravo! Ang galing mo. Ang galing mo, paring Nick. There's just this, really beautiful tingling sensation when you hear that British accent of an Attorney Nick Kaufman and those stresses and those sudden movements. Oh, yun. Ayan na. Tawag-tawag na sila.
We are back in open session, Madam President.
Okay.
Donc, si j'étais un...
Judge Mochok, I was thanking the participants and parties, and then we had a few moments in private session, and now I would like to wish you a pleasant afternoon. We will see you all tomorrow, and once again, I thank everyone, and this hearing is...
Okay. Okay, so yun na yun, adjourn na. So bukas na tayo ulit, no? Alas 5 ng hapon bukas dito sa Pilipinas. At defense, isang oras. And then closing statements ng prosecution, closing statements ng victims, no, yung common law legal representatives of the victims, CLRB, kasama yung mga Pilipinong lawyers, and then closing statements of the defense, and then later in the afternoon tomorrow will be the hearing on the continuing detention of former President Duterte, kung itutuloy pa ba o hindi. Wala tayong masyadong expectation dyan. Pero hindi natin alam, no? Baka the court will grant for his interim release. So abangan natin 'yan bukas. Again, marami pong salamat. This is E.B. Ugalbot at antabayan po natin bukas ang last day of the confirmation hearing or the confirmation of charges hearing ni former President Duterte. At sana po ay suportahan pa rin natin ang ating presidente at ang ating vice presidente. Nasa House Justice Committee na ang kanyang for impeachment complaints at titingnan natin ang mga developments, no? Again, thank you so much at magandang gabi po sa inyong lahat. I'll see you again tomorrow.